So, good morning, everyone, and welcome back to the IP Masterclass series as part of the IP UTSAV 2025, jointly organized by AICP and Ministry of Education's Innovation Cell. So, today is April 23rd, which marks the World Book and Copyright Day. And I'm thrilled to have you all here for this special occasion on copyrights and uncovered. So before we dive into this, I have few quick note for the participants, especially for the new participants. Please note that at the end of today's session, we'll be sharing an e-assessment and feedback link. This is to reflect yourself that what we have learned and gained through this session. And also know that the participation certificates will be awarded to only those participants who have qualified the assessments for the 4 days of this program. And please feel free to have any queries. You can use the chat box through the WebEx or the YouTube link. So in this book, in this World Book and Copyright Day, we have two incredible domain experts in the field, Ms. Anooja Padhee from K&S Partners and Dr. Hemant Khosla, the Deputy Registrar of Copyrights with the Government of India. So without any delay, let me first begin by warmly welcoming our first speaker, Ms. Anooja Padhee. Is a partner at K&S Partners, which is one of the India's topmost IP law firm. And she is a true powerhouse in IP law, bringing deep expertise in trademarks, copyrights, and GI. She has worked with clients all across diverse sectors such as FMCG, clothing, textiles, and beauty. She is an expert in managing IP portfolios, prosecution, enforcement, and complex cases such as oppositions and infringements. Beyond that, she is a master at drafting and negotiating IP license agreements and plays a pivotal role in registration and prosecution of GI in India. So on behalf of MIC and AICP, we are very much thrilled to have you, ma'am, in this session. So over to you, ma'am. Miss, please take over this.
Um, Thank you so much, Shruti. Hello, everyone. I am Anooja, and I'm thrilled to be here and make this presentation before all of you. So I'll just be sharing my screen, and then we can just dive right into it. Can you confirm if you're just able to see my screen?
Yes, we can see.
All right. Okay.
Yeah, just you need to, yeah.
All
No,
right.
it's
Okay.
perfectly fine. Yeah.
Okay. Thank you. So the presentation that I'll be making today is on introduction to copyright. We'll discuss the law, we'll discuss some aspects of enforcement and some challenges that are being faced in the copyright world today. We'll do this with the help of some legal provisions and with the help of some case laws, old and new. So if you see, the first question that comes to mind when you listen to copy, when you hear the word copyright, is like, what is copyright, right? And copyright is exactly what the word says. It's the right to copy. So and the owner of the copyright and anyone that's authorized by the owner are the only ones with the right to reproduce any work. So copyright protects the expression of a particular idea, the manner in which it is made. The work has to be an expression. It has to be a combination of things, and copyright does not protect an idea per se, right? You may have an idea. Four people may have the same idea, but if the manner in which the idea is expressed by these four people differs and there is originality in each of the four works, then each of the four works can be protected, even though the idea may more or less be similar and may eventually lead to the same or similar result. Then the next basic point that we need to remember is that copyright is automatically created as soon as the work is created. So if an original copyrightable work is created, then automatically copyright vests in it by virtue of creation. Which brings us to the next part, that registration as such of copyright is not mandatory. And while it is definitely recommended because it acts as prima facie evidence of your ownership in the work, and it acts as legal evidence in case of an infringement or in a court case, etc. But it is not a mandatory requirement, and the copyright in a work vests by virtue of its creation automatically. So next, we'll look at what is the legal framework for copyright in India. So it is governed by the Copyright Act of 1957, which was last substantially amended in 2012. It is administered by the Copyright Office. That is, if you seek registration, then it is the Copyright Office that administers that, which comes under the Ministry of Commerce and Industry. Um, India is a signatory to, with respect to copyright specifically, India is a signatory to major international treaties. There are several others, but these are the two main ones in my view. One is TRIPS, which is Trade Related Aspects of Intellectual Property Rights Agreement, and the second is the Berne Convention for Protection of Literary and Artistic Works. Uh, TRIPS is both of these treaties actually set the minimum standard for IP protection for its member nations. TRIPS it relates to IP in general, and while there are specific chapters for different kinds of IP, Berne Convention is specific to copyright. In fact, it says that if a particular work is protected in a country, um, is protected in say one country, then it will be protected in another member nation as if it were a domestic work there. Now, for example, if both Canada and India are signatories to the Berne Convention, if a work is protected in Canada, then by virtue of its protection in Canada, it automatically gets protection in India as if it were an Indian work, it gets as if it were a domestic Indian work. So that's the advantage of being a signatory to the Berne Convention. So this is the principle of national treatment that I just referred to. So, question arises as to what all can I protect, right? What all can I claim copyright in? So there are several different kinds of works. The first is the literary work, which is the actual written word, the written text. So books, computer programs. Now, computer programs meaning software can be protected as copyright. It is so you have to give the object and object code and the subject code of the program itself, and that is what is protected. Then you have dramatic works in which choreographic works or plays or screenplays, etc., are protected. Then you have musical works, which are compositions and the notation of a particular work is protected as copyright. Then you have artistic works like paintings or sculptures or photographs or architectural works, etc. Then you have cinematograph films, which are visual recordings, so your movies or your YouTube videos, these short films, anything that you watch as a video um, on a visual platform is a cinematograph film. Then you have sound recordings, which are recorded audio songs. These are songs or any other kind of audio as such. Now, what is who owns these rights, right? So, because there are several different kinds of works, so there can be who are the owners of these works. So, the first rule of copyright that you need to remember is that these are for original works. Now, originality is a big thing in copyright. You can only claim copyright if a work is original. So if in original works, like in first hand owner is the author of the work. Now, author meaning the person who created the work. So in case of literary works, it's the author, that is the creator of the work. Then for dramatic works also is the author. For musical works, it's the composer of the music. For artistic works, it will be the artist. Then for a photograph, it will be the photographer. Now, there are some other kinds of work as well, right? Like derivative works, which include cinematograph films, sound recordings, etc. Now, derivative works are when you use the original works to derive something and make another work out of it. Now, for example, a cinematograph films contain dramatic work, it contains music, it contains a lot of other things. So, a derivative work will be owned by the producer. Then a commissioned work, like if I say commission someone to make a painting for me, there I am the owner of the work because I am the one commissioning it. And then the third part is where work is created in the course of employment. There it is the employer who that's the owner of the work, unless of course there's a contract to the contrary. Okay, so what kind of rights does a copyright owner get? Um there are a bouquet of rights that you get, which broadly can be divided under two heads. One is economic rights, and the second is moral rights. Now, economic rights are fairly straightforward. The right to reproduce a particular work. Say I wrote a book, right? The fact that I want to make 50 copies of the book is a right of mine as a copyright owner. I want to make these 50 copies and distribute them. I want to sell them in a bookshop. So that's my right. Then, and third is I might want to make a enact this out before the public. That's a public performance right that I have. Then I may want to, it's an English book, I may want to translate it into Hindi and adapt it into a play or adapt it into a movie or something. So that's again an economic right that a copyright owner has. So these are broadly the economic rights, basically the kind of rights that you could generate some kind of compensation or remuneration from. Uh, then you have moral rights. So moral rights are specific to copyright actually, and there are two main kinds of moral rights. One is the right of attribution, also known as the right of paternity. Means that a person will always have the right of a particular work being attributable to them. For example, say Mr. Javed Akhtar writes some lyrics for some song, right? And the lyrics are assigned to the producer who eventually makes, this a song is made, etc., etc. So the copyright in it may not belong to Mr. Akhtar, but he will always be at the fact that he's the one who wrote those lyrics will always be attributed to him. So that is his moral right, the right of attribution. Then there's right to integrity. So as a copyright owner, or as a creator rather, I have the right to integrity, which means that I have the right to um, object to any kind of defacement or any kind of derogation that is done against my work. Now, for example, I am a sculptor, I make a sculpture. If someone, or I make a painting, and someone decides to write some filthy language on it, or paint over it, or do something like that, I have the right to object to it. So I have that is the right to integrity. So then we'll talk about duration of copyright for literary, artistic, and musical works. It's the lifetime of the author plus 60 years. So say I created a work at 50 and at 20, and I live for another 50 years. So that's 30 plus 60 years. So it's my lifetime plus 60 years. Then for films, sound recordings, and photographs, it's 60 years from the date of publication. Now, for example, if a movie released on, say, 1st January 2020, then the copyright in it will vest till 1st January 2060. Not 60, sorry. If it released on 1st January 2000, then it will vest till 1st January 2060. Now, what happens after a work, the duration of copyright expires? Once the copyright expires, it moves into public domain, and then it can be used by anybody. Now, in fact, interestingly, at some one point, the song, which the most popular song in the world that we sing almost every day is Happy Birthday to You. Now, Happy Birthday to You was at one point a subject matter of copyright, and its heirs decided to file a suit, and there was a case decided in the US in 2015 in which the court finally said that no, now it's in the public domain, so you can't really seek a license for its use. Um, so yeah, it goes into public domain after the expiry of the copyright in it. Now we'll discuss a few principles that form the basic tenets of copyright in India, and these tenets were evolved through case law. We'll discuss two of them. One is the idea expression dichotomy, which was discussed by the Supreme Court in the case of R.G. Anand versus Deluxe Films and others. Like we discussed earlier, no copyright exists in an idea, right? It is the expression, the original expression of an idea that can be protected as copyright. So the protection in any work is confined to the form, the manner, the arrangement, and the expression of the idea. So what happened in this case was that Mr. Anand claimed that Deluxe Films had copied the idea of one of his plays called Hum Hindustani, and Deluxe Film made a movie called New Delhi, and he said that it was infringement of his copyright in the play. So the court looked at the facts, etc., and then maybe the basic idea, maybe there may be some sort of similarity in it, but there were enough differences. And in this case, the court laid down certain principles and categorically said that it is not the idea, but the expression of an idea that is protected under copyright. So, if you read the, like we've written here, it is the original expression of thought or information in some concrete form that is protectable subject matter under the act, and not merely an original thought or information per se. In this case, the court also talked about, how do you make out whether a work is original, whether there is any sort of infringement that's happened from a previous work. Now, are there substantial similarities in the works? um, if I view a particular movie, sometimes it happens you watch something and you're like, oh yeah, it was similar, but would you necessarily will the subsequent work bring the initial work into your mind? That is the test. Will you think that yes, there is a it has been copied, it's the same thing? When there may be a lot of stories which may have similar ideas, but it is the expression of the idea that is important, and that was what was held by the Supreme Court in RG Anand versus Deluxe Films. Now, the second case that is again a landmark case in copyright in India is the case of the Eastern Book Company versus DB Modak, which was again a Supreme Court case in 2008. So, in this, what happened was EBC is Eastern Book Company. It publishes a compilation of Supreme Court cases called SCC. It adds features like formatting, cross referencing, page numbering, case notes, etc., to make it more user friendly. And so EBC claimed that Mr. Modak's company, that is the respondent, had copied their module SCC and converted it into CDs, and they were distributing these CDs to the public. So, based on this, EBC claimed that their copyright was being infringed. Then the respondent argued that EBC's publication lacked originality because it was only a derivative work from the judgments. The judgments were in the public domain, they didn't do anything to it, they were just compiling these judgments together, and so there was no originality in their work, and hence it is ineligible for protection. Now, here, like we've discussed several times already, the work needs to be original. So, what is the law around it? The law is that the work, the subsequent work, the work which comes into being should be original in the sense that by virtue of selection, coordination, arrangement, etc., of pre existing data contained in a work is somewhat different in character than the original work, right? So you may make additions to it, you may compile it in a certain manner, whatever it is that you do, the work that is generated must be different and original in its own right. So what the court had to look into was whether EBC's efforts had transformed the original judgments that were in the public domain sufficiently to make them original works in their own right. Now, here the court, there there was a difference in there are two tests that the court looked into. One is the sweat of the brow test, which basically says that if you put in effort and if you put in a lot of hard work into something and you expend your skill, etc., that is enough for it to make something copyright protected. This is the sweat of the brow test principle, not test. And then from here, the court went to the modicum of creativity principle, which is that while you may put in effort, while you may put in a lot of hard work to create something, it also needs to involve certain intellectual effort and a certain degree of creativity. It can't just be that I've put in effort, so this is copyright protected. Now, this also flows from the fact that a work needs to be original, right, and substantially or at least significantly different from the original work, from the first work. So, which is why a certain degree of creativity is required to be put. So, this is the modicum of creativity principle that the court applied and said that even though the underlying material, which is the judgments, are in public domain, the work that was put into by EBC in editing, arranging, formatting these judgments, etc., are protectable as they meet the threshold of creativity that is required. So these are the two main cases, one of two landmark cases in copyright law, and a lot of the cases that are decided in India are based out of these two. Now let's come to infringement violation of copyright. So when does someone's copyright get infringed, right? So in simple terms, what is infringement? Copying, distributing, or performing anybody's copyrighted work without their permission is infringement. It can happen in two ways. It can either be direct or indirect. Now, what is direct infringement? Is that if, say, I am the copyright holder and I have the exclusive right, if you do something that is my right exclusively and I have not authorized it, then it is a direct infringement. So if a person does anything which is the exclusive right of the copyright holder as conferred under the act, then it is a direct infringement. Then there could be an indirect infringement in which if a person uh, allows for profit allows use of any place for communication of a work to the public, decides post a movie or a work that is copyright protected and they know that it is an infringement, but they allow it to be hosted on their website, then it amounts to indirect infringement. Them allowing the hosting of this work on their website would be an infringement. That is an exception to indirect infringement. Then there are other acts as well that can be considered to be infringement. One is distribution of infringing copies for the purpose of trade, to an extent that it affects the copyright owner prejudicially, or importing an infringing copy. Now, this is not just one copy. One copy can be for private use,
Hello, ma'am.
which is unacceptable.
Sorry to
Yeah.
interrupt. I think your
Yes.
slide is not visible right now. Could you please reshare it?
Okay.
Yeah, and your
Yes.
voice
Yes.
was also breaking in between.
Oh, okay. Are you able to see it now?
Not yet. Yeah, now we can see it. Yeah.
Yeah.
Yes, yes.
Do you want me to repeat a slide? Which slide were we on? I mean, we were
No,
on
no, you
this,
can.
but
Yeah, you can carry on. We were on this slide only.
all right. Okay.
Yeah.
Oh, sorry. Yeah. So importing of an infringing copy, not one copy, but for if there are several, then even that could amount to infringement. Now, there are some statutory exceptions. These are statutory defenses that are provided for under the Act, defenses to infringement. Um, there are several. We've put in some key items here. Now, fair use is the biggest defense that is available, that my use of the copyright was fair dealing. That is, it was for either for private use or for research or for satire or criticism or for review of a work, or for reporting of current events. Basically, if my use amounts to me being the infringing party, if my use amounts to fair use under the Act, then it is a defense against infringement. Or if there is transient or incidental storage, means if it was only being stored or communicated for a very short while, or if it just happened to happen, because not because it was an intentionally done thing, then it is transient or incidental storage. Then if it is for reporting of a judicial proceeding, or if someone reads out or recites excerpts of a published work in public, or if there is reproduction by teachers or by students during instructions, or if there is a report in the newspaper of a lecture that has already been published, so the report or a review in the newspaper, performance by a non-paying a performance of by an amateur to a non-paying audience. Now, tomorrow, if I decide to go and sing on stage, I've no the song I'm singing, the owner of that song can't come and sue me for infringement, because if as long as it's a non-paying audience, or for the benefit of a religious institution, or storing of the work in a non-commercial library, making copies of a book by a non-commercial library if the book is not available in India. Now, if you see, a lot of it is also if I'm deriving commercial benefit out of it. If as long as I'm not deriving commercial benefit out of it, it could be a statutory exception. Of course, that's not a hard and fast rule, but broadly, that's what it could be said that that is how it works. Now, those are statutory defenses that are provided for under the Act. Now, there are some common law defenses that have been, because India is a common law country and we don't just follow the letter of the law as provided in an act, but courts in India also evolve the law and they also make law. So these are common law defenses, that this is a common law defense that has been laid down by courts in India. So this is premised on a legal maxim called de minimis non curat lex, which translates to the law does not concern itself with trifles. Now, trifles meaning like small, insignificant issues. So, the applicability is that very minor or insignificant uses of copyrighted material will not be will not be actionable or may not be actionable, because the law will not typically scrutinize or act against copyright violations that are too trivial, too small. to warrant any kind of legal intervention. So this is another defense that a party may make, that my use was very, very minimal and it's barely even there. So it falls under this maxim and hence is not actionable. Then we'll come to what are the civil remedies that are provided for. First is who can be the plaintiff if I decide to sue someone. Then who can be the plaintiff? One is the owner of the copyright or their exclusive licensee, not a non-exclusive licensee. An exclusive licensee that only, other than the owner, only I have the right to use it. So only these can be the plaintiffs. Reliefs are injunctions can be issued. Now, injunction is if the infringing party is stopped from carrying out their infringing activities. Then damages, whatever damage I faced because of the infringement, I am eligible to get that money back. Now, costs are discretionary. Costs are basically it's usually done in an exemplary to make set an example. So because somebody was doing something that was illegal, costs are imposed on them in addition to the damages. And delivery of the infringing copies or equipment that is used to produce the infringing material. Now, where the defendant proves that they had no knowledge, this is in the case of indirect infringements, where defendant proves that they had no knowledge or reasonable belief that the work in which they were dealing was copyright protected, only injunction is granted and damages or rendition of account, that is damages, are granted, and the rest need not be granted. That of course depends on the subjective discretion of the court. There are also criminal remedies available, but like is applicable for all criminal matters, the first prerequisite is that there should be intention, mens rea. There is intent to infringe. That is a prerequisite. Now, here the police can search and seize someone's premises and seize copyright infringing copies and plates and equipment etc. without a warrant, and then file a complaint before the first class magistrate. Then punishment can range from 6 months to 3 years of imprisonment, plus a fine of 50,000 to 200,000. Uh, then there can be, if there is, it wasn't being done for gain, the infringing activity, then for commercial gain, then there is a discretion on the judge to grant a lesser punishment, but there is also enhanced penalty for second and subsequent infringements, with the minimum imprisonment term becoming 1 year and the fine being 100,000. Now, we'll discuss something that, because this year's WIPO theme is music, I think it's important that we discuss some copyright aspects with regard to music as well. But for that, and we'll discuss a case for that. But let's first talk about copyright societies. Now, what are copyright societies? Copyright societies are societies that are registered under the Act to help owners of copyright grant license grant licenses for use of their copyright and for ease of the public to seek such a license. Now, for example, if I want to use Kal Ho Na Ho, the song somewhere, uh, I don't know. I know that the song belongs to probably Dharma Productions. I don't know how to approach Dharma Productions to get rights to the song to use it somewhere. And so what will I do? I will approach a copyright society that owns the song. So what happens is that copyright owners assign their rights to these societies, who in turn assign, meaning they sell their rights to these copyright owners, sell these rights to the copyright societies, and then these societies grant licenses for on behalf of the copyright owner. Now, the act bans carrying on of business of issuing or granting licenses for copyrighted work except through registered copyright societies. So a body cannot carry on the business of issuing or granting licenses en masse. Like, you cannot make a business out of it for granting these licenses unless you're a copyright registered copyright society under the act. Cannot make a
If a
business out
copyright
of it
society is
for
being managed in a
granting these
manner
licenses,
that is
cannot make a
detrimental to
business
the
out of it
interests
for
of either
granting
of
these
the owner,
licenses
then its
unless
registration may
you're a
be cancelled.
copyright registered copyright society under the
And
act. There's a
if a
case
copyright
which said
society
that
is being managed
unlike
in a
a
manner that
registered
is
copyright society, an
detrimental to the
agent
interests
cannot
of either
issue
the
licenses in
owner,
its own
then its
name. It can
registration
only
may
do it through a copyright society. You have to be a member of a copyright society to be able to do it. So these are a few copyright societies. These are in fact the only copyright societies that are registered in India. So if you see for different kinds of works, there are different societies that are registered. So if you see, the first one is for literary works that are associated with musical works. For example, that's for lyrics of a song. That's IPRS, that's Indian Performing Rights Society Limited. Then for photocopying works, you have Indian Reprographic Rights Organization, IRRO. For singers performance, you have Indian Singers Rights Association. For recorded music performance, you have RMPL, which are for sound recordings for songs. Then for cinematography, for movies, you have Cinephile Producers Performance Limited. That's Cinephile. Now we'll discuss the case which for which we needed to understand what copyright societies are, and this is a very recent case that's happened earlier this month, in fact, and decided by the Delhi High Court. It's still sub judice, but this is the preliminary interim order that the court has granted. So this is Azure Hospitality versus Phonographic Performance Limited. Let's call it PPL. Azure is a company that operates multiple restaurants all over India, and PPL is a copyright collective that is in the business of issuing licenses for publicly playing songs. Now, PPL is a copyright collective which owns the copyright in lot of from a lot of music record labels, and it issues licenses for the use of these songs in public. PPL was a registered copyright society till 2014. It is not a registered copyright society as of today. It owns public performance rights of 400 plus music labels, which with more than 4 million international and domestic sound recordings. So it's big. It's a big party. Now, PPL filed a suit against Azure for playing songs it owned in 86 of its restaurants without seeking a license. Azure argued that PPL is not a registered copyright society under the Act, and that is why it cannot issue licenses or sue for infringement, which is what the law says. But the single judge of the Delhi High Court held that because these rights were assigned by music labels to PPL through assignment deeds, PPL became the owner, and hence it had the right to license these rights despite not being a copyright society. So PPL could license it as the owner of the work even though it was not a copyright society. Now, Azure filed an appeal before the division bench of the court, and which overruled the order of the single judge. The division bench said that Section 33, which talks about which talks about how a company cannot function in the business of issuing licenses, is prospective. Now, it unequivocally prohibits any person from carrying on the business of issuing or granting licenses in respect of any work in which copyright subsists, unless you are registered under Section 33, which is registration as a copyright society. So, under Section 33, only a registered copyright society is permitted to carry out the business of issuing licenses, and PPL cannot issue licenses for public performance because it is not a registered copyright society. PPL made the same argument that the single judge had made in its favor, where it said that, I'm the owner. But the court said that you may be the owner, but you are issuing licenses en masse, and you are in the business of issuing licenses. So, if I were to allow your argument, then the regulatory regime it becomes redundant. There's no point of having a specific bar on non-registered copyright societies issuing licenses if I were to allow this argument. So, which is why people lost the the interim order before the division bench, and was direct. But because at the end of the day, Azure cannot be allowed to use this music free of charge because it is copyrighted work at the end of the day. So the court ordered Azure to pay PPL for the songs played by it, a sum that is charged by RMPL. Now, RMPL you saw earlier was the Registered Copyright Society for sound recordings. So every copyright society has its own tariff based on which money is paid, a license fee is paid. So as so the court said that Azure will have to pay PPL along the lines of RMPL's tariff, as if PPL is a member of RMPL, and PPL will not be allowed to use its own tariff. Now, this specific direction has now been stayed by the Supreme Court in an SLP day before yesterday on April 21st. So, not the fact that PPL can't issue licenses, that part still remains. But the direction to make payment based on RMPL tariffs has been stayed by the Supreme Court. And now we'll just wait and watch and we'll see what happens in the case. This is still ongoing. Now, another burning issue in copyright these days is the challenges that we face because of work that is created by AI and the copyright that vests in it. So, author, what are the main issues that we face? One is that author, in relation to any work, is the person, author in relation to any literary, dramatic, musical, artistic work, etc., which is computer generated, which is generated by a software or by a computer, is the person who created the work. Now, currently only human beings own copyright in India, right? But when it's AI generated, now for example, if say I ask ChatGPT to create some story for me, I ask it to please write me an essay on copyright in India. So who owns the copyright in that? Do I own it because I put in the question, but I didn't create it. The AI did. So can I say that I own the copyright? Now, can the AI own copyright at all? It's not a human being. Can AI own copyright because they are the ones who seem to have created it? Or is it OpenAI? OpenAI is the owner of ChatGPT, it's the main company. So, does OpenAI own it? But OpenAI says that they train AI models. So, do they own it? Who owns the copyright if ChatGPT comes up with a story or a composition or whatever? Now, these kind of questions are arising all over the world, including in India in a case, and copyright infringement suits are happening because of this. And because of this, what happens? It becomes difficult to stand out in a crowd with your own creation because it's not what you think from here; it's what the AI is thinking for you. So it could lead to stunted creativity and thinking because you're not thinking on your own. A machine is thinking for you. So, copyright infringement suits. Now, this is a copyright infringement suit that has now been filed before the Delhi High Court by Asian News Network (ANI) versus OpenAI, which is the owner of ChatGPT. This is the first case which discusses copyright issues by AI in India, and it has still not been decided. But it's worth a discussion definitely here because it's the first of its kind, and this is only going to increase in the day and age that we live in, the digital world that we all live in, and with the use of AI in almost every aspect of our work and life these days. This will soon become the norm. So, what happened in ANI versus OpenAI, which was filed before the Delhi High Court in 2024, I think late 2020, network, and they claimed that OpenAI was using copyrighted news content without authorization from ANI to train ChatGPT. It had no, they said it had no right to use its content for profit, even if the material was freely accessible online. It was available everywhere because it's news, right? So it's available, it was freely accessible online, but ANI said OpenAI does not have the right to use it. Then it also said that OpenAI must comply with copyright laws and for AI training, which means basically going around the web and using content that is available without compensation, amounts to commercial exploitation, because content creators have the exclusive right to decide how their work is supposed to be used. Based on this, they filed a suit against OpenAI and claimed heavy damages. What does OpenAI have to say in response? OpenAI said that Delhi High Court doesn't have jurisdiction because it is a US based company, it has no physical offices, and does not have operational servers amount to copyright infringement. And if
Hello,
a
ma'am.
publisher,
I think
yes,
we lost
again,
you. Yeah. Could you please reshare? Yes.
yeah, I'll just do that. I'm sorry, I think I'm facing some internet issues.
No,
I'm in
it's okay.
office,
It's
but
fine. Yeah.
okay. Can you tell me if you can see my screen? I'll just
Yeah,
risk you
it's
connecting.
loading. Yeah.
Are you able to see it?
Yes, yes. Now it's fine. Yeah. Thank you.
Okay. So can you tell me where to, do you want me to repeat a slide or can we,
No, we can start continue with the OpenAI related
you were here
case.
itself, right?
Yes, yes, yes.
Before this, okay. All right. Okay.
Yeah.
They also, so, okay. OpenAI also said that if I'm a publisher seeking to protect my data, then it is
Original. So
my
what is the law
responsibility
around this?
to issue
The
website
law
restrictions
describes the
such as
work,
paywalls,
the
anti-scaling measures,
subsequent work,
etc.
the work
Because
which
placing
comes.
the burden on AI developers would stifle technological innovation. These are the submissions claims that have been made by both sides, OpenAI and ANI, based on which court has uh, has created four issues that that it is considering. These four issues are still being considered. The court has not issued an order so far. It has also heard amicus curiae, who help the court in understanding what the law is and what issues they may consider. So the first question that the court is considering is whether storage of ANI's data by OpenAI, which is news. Now keep in mind that ANI's data is news, and they are claiming that news is copyright protected. For training its software would amount to infringement of ANI's copyright, which will mean that you have to first decide whether news itself is copyright protected because it's in the public domain. So one of the things that OpenAI said, it's all in the public domain, right? So how can you stop me from using something that's freely available? So that is the first question that the court has to decide. The second is whether use of ANI's copyrighted data to generate responses from users would amount to infringement of ANI's copyright. One first is storage and training. The second is for generation of responses by ANI. Does that amount to copyright violation? Third is, does an OpenAI's use qualify as fair use under the Act? We discussed, right, that fair use is a defense to infringement under the Act. So, is there anything under the Act which allows OpenAI to claim that it's fair use? Maybe the fact that it's in the public domain, we don't know. And the last question is whether courts in India have jurisdiction over OpenAI because they are located in the US and they don't have servers or offices in India. So, do Indian courts have the jurisdiction to entertain such a lawsuit? These are four main issues that are being considered by the court. Again, it's still underway. We don't know what's going to happen. But I feel it's a very interesting area, and we should keep a watch because, like I said, AI has taken over our entire lives, and soon it will become the norm. If Because ChatGPT is being used very, very rampantly. So yeah, that's it from me. Thank you for being patient and hearing me out. I'm happy to take any questions that you may have at this point.
Thank you so much, ma'am, for traveling us through this legal aspects of copyright, especially through the case laws and about the burning cases of open generative AI. It was really insightful.
Yeah.
Now, I think participants, we are open the floor for queries. Please raise your hands for any queries, or you can post it in the WebEx chat box or the YouTube comment section. Uh,
Hello.
yes, it's okay. Yeah, yeah. You may proceed. Yeah.
Hello, madam.
Hi.
When after this chat GPTs and all, when we
Yeah.
publish our data onto the websites and web applications,
Right.
and is there any specific laws to support that they have copied our content or they are using our content?
Um,
Is it
so as of
covered
now,
by Data Privacy Act?
no. So Data Privacy Act currently covers, as far as my information goes, personal data. But copyright protection will be for a work. Now, for example, if you write an article on some subject and you post it online, and ChatGPT decides to use it and to generate responses or train its AI, then does it amount to copyright violation of your copyright? That's something that the court is deciding right now in the case that we discussed last, because it's a gray area. Um, it is not protected under data privacy because data privacy discusses your personal data. So I personal identifiable data is the one that is covered under data privacy. um, I hope I've answered your question.
Yes, sir. So we'll move to the next question, ma'am.
Yeah.
I think Professor Dr. Neeraj has raised her hand.
Dr. Tapan sir, maybe you could ask your question.
Very good afternoon, ma'am. This side,
Good afternoon.
uh, this side, this side, Professor Dr. Neeraj Marwa from Sri Sai University, Palampur, Himachal Pradesh. My question is that
Hello, doctor. Hello.
Yes, Dr. Tapa, please proceed. I think we lost.
I think we lost Dr. Marva in between.
Hello.
Yes, Dr. Tapa, please go ahead.
Okay, okay. So, madam, I have a simple question. Suppose if you go to the AI tools, suppose you are creating some content, maybe some answer of particular questions. That if
Hmm.
these are published, any kind of copyright infringement that is occurs or not?
You mean the questions that you pose to an AI tool?
Yes, questions or any kind of uh, essay
Information that you
or
may give to an
yes,
AI
yes,
tool?
yes,
So
yes,
the information, if I am giving it to an AI tool, then that will depend on the nature of the information. Like again, we discussed in the previous question and in the case, as if a work is copyright protected. Now, if the question or the essay, as you referred to, is an original work of mine and that is, I'm voluntarily giving it to OpenAI, then it depends on the terms and conditions of ChatGPT. We'll have to read the terms and conditions very clearly to see whether I am by doing so, am I consenting to the use of my work uh, to train the AI. But the first question that you need to see is that whether the work itself is copyright protected or not, whether it is original enough to be um, to claim copyright in it.
So, thank you.
Now I think Dr. Neeraj. Hello.
Hello. Yeah, good
Yes,
afternoon to
sir.
everyone.
Yes.
My question is that because after getting the patent, what is the age means after say, I repeat my
I'm
question.
sorry, I didn't. Yeah, I didn't get your question.
Yeah, means once I get a patent, then after technology transfer, what is the age of that patent?
I am not sure because I'm not a patent lawyer. I know that I mean we can discuss duration of a copyright, and if you're referring to a computer software, then the age of or the copyright duration for that computer software will be 60 years from the date on which it was published or made. But I'm not sure of the age specifically of a patent. I'm sorry.
Once the technology is transferred. So
Right.
means that patent is novel, it is already transferred to some company or some multinational concern.
So, if you transfer your technology to someone, it depends on what rights are being transferred under the patent. If you're doing it as a whole and you're doing it like at least in terms of copyright, when you do it, when for any technology transfer that happens, there are several rights that may or may not be transferred. I may retain some, I may assign some. So, it depends on
Yeah,
that if
yeah.
you're retaining anything.
Okay. Okay,
Okay.
ma'am.
Thank you,
So nice
Doctor.
of you. Thank you.
Now we have a few questions from the WebEx chat book. Um,
Yeah.
Venkat Narayan is asking, can you assist us in filing a copyright through IPR website and documents and the forms which need to be uploaded? I
I
think
think you have Mr. Khosla taking the next session who will be helping with that, right?
yes, ma'am. I think
He is the expert in filings and the documentation required, so he'll be helping you with that.
yeah. So we have another question: how news will be copyrighted? On what basis? Is it the content which they write?
So yes, that is again a gray area. Again, something that probably will be discussed in the ANI versus ChatGPT, the OpenAI case. But my view is like we discussed. So the subject matter of news. Now, for example, if you say that. I'm sorry to be using this example, but a terrorist attack happened in Kashmir yesterday. So that is the news, that is the content. But if, say, how you write it down, what do you write about? What are you looking at it from a different angle? How are you presenting it? If there is some originality in that, then that can be protected as copyright. But because this is news and that's in the public domain, that by itself, in my view, cannot be considered to be copyright protectable work because it's not something that is original in that sense.
Okay, thank you, ma'am. And we have Anand asking, is software or a mobile application can only qualify for copyright, or can it be made patentable too? If so, how it's done?
So software mostly is protected under copyright. So the like I said, the source code is protected. Like if you make an app, the app itself can be protected as copyright, but how the app functions and what it does, depending on the functionality of it, may or may not be patentable. But the software, it's difficult to patent software. There has to be some. Now for example, if it's a phone, then phone in which the software is used, the software is copyright protected, but the manner in which the phone functions and the functionality of it may be patentable material.
Okay, thank you, ma'am. I think we have a lot many questions, so we will uh, wind up with one more question. So Narayan is asking,
Yeah.
an author publishes a paper in a journal to whom there is copyright transfer. The author places a copy of the paper in personal website or sends a copy to people requesting for the same. Is it copyright infringement? Is asking.
Sorry, if I write, or a person writes an article and then publishes it in a paper, and then if people ask for it, then he sends the article to these people. Is that the question? Is that copyright violation?
Yes, ma'am. I guess so. Yeah.
No, because if I've written the article, then again it depends on my contract with the newspaper. But my hunch is that I would retain the copyright, even though it may be published in a newspaper or in a magazine. I don't think the magazine will own the copyright in it, or it depends on the agreement between the two parties. But if I own the copyright, then I'm free to show it to people. Also, if someone just asks for it and I'm just sharing an article that I've written with them and for no commercial gain, then I don't see why it would amount to copyright violation, even if the copyright is owned by the newspaper or the magazine.
Yes, ma'am. So, thank you so much. We have a lot many questions, and due to lack of time constraints,
Yeah.
and we have another session in the queue. So,
Yes.
sorry, participants, due to time constraints, we are not unable to take up more questions. So, thank you so much, ma'am, for your valuable insights and traveling through this aspects of copyright. Thank you so much for your time here. And
Thank you so much. Glad
yeah,
to be
on
here.
behalf of
Thank you so
MIC
much.
and AICT, I thank you all for joining this. So now,
Thank you. All right. Can I can leave, right?
yes, ma'am, thank you. Thank you so
All right.
much.
Thank you so much.
So now, let's introduce our second distinguished speaker, Dr. Hemant Khosla. He is the Deputy Registrar of Copyrights with the Government of India. He's a renowned legal scholar with LLB, LLM, and a PhD, where his research is focused on international trademark registration under the Madrid Protocol. He has completed over 10 specialized courses from the World Intellectual Property Organization, showcasing his dedication to mastering IP law. Since 2020, he has been overseeing copyright registrations and amendments in India, earning him widespread respect as a leading voice in copyright law and policy. So we are very much excited to hear his insights, especially on this World Book and Copyright Day. So with this, I now invite you, sir, for this session. So over to you, sir.
Thank you very much, ma'am. I'm audible, ma'am.
Yes, ma'am. Yeah. Yes, sir. You're
Thank you for
audible.
inviting me for on a very great day, because today is the World Book and Copyright Day. So let's talk about the copyright. And I don't think so Anuja ma'am has left anything in copyright, and it's a tough job for me now, how to handle with these all these copyright stuff, because she almost cover each and everything. So without wasting any time, can you share my slide, ma'am?
Yes, sir. Dominic, could you please share the PowerPoint, please?
Ma'am, Damni sharing. Oh, 2 minutes. 2 seconds.
Yes, sir. Yes.
So we should start without wasting the time to
Yes, sir.
open up
Yes,
the
sir.
slides.
Yeah.
Before that, I would like to tell you what Copyright Office is doing right now regarding the copyright. One thing is we are giving the registration to the copyright in different spheres. So that is in literary, artistic, cinematograph, film, sound recording, and software. The another job we are doing, we are receiving the application for the copyright registration for the society, and then it's forwarded to the Ministry of Commerce and Industry, DPIIT, for generating the registration certificate. And what is the copyright society is that to doing the business of the copyright work in the different spheres, like in literary, cinematograph films, sound recording, and the copyrighted, the photocopy work, and so on. So, what documents you needed for the copyright registration? Ma'am, can you, meanwhile, can you try to uh, put the slides?
Yes, sir. I think there is some technical issue. We'll be
It's
sorting it
okay.
right away. Just a second. Yes, sir.
It's okay. It's okay. So, if you want to have a registration in the literary work, then you need to file. There is a form that is very easy form. That is a form 14. What included in form 14 is a statement of particulars, statement of further particulars. If the author and owner is different, then you will have to take no objection certificate from author. Hope you understand what is the basic difference between the author and owner. uh, Anuja ma'am has clearly make the difference between who is the author and who is the owner of the work. So I am not touching this point right now. So if there is a difference between the author and owner, you will have to submit the no objection certificate from the author. If there is a publisher, suppose you have published your work, literary work, then you need to give a no objection certificate of the publisher. One copy of the work which you want to get a registration. If the application is filed by the attorney, then you will have to give the power of attorney. If the application is moved by the private limited company or limited company, then you need to submit board of resolution letter of authority in favor of the signatory of the application. So this is the case when you are applying for the literary work. Suppose you are applying for the artistic work, for the copyright. If you want to have a copyright in artistic work, there are three kind or three way you can have a registration over the artistic work. One, where the artistic work is used for the goods and services. Suppose there is a logo of Maruti Suzuki, Kia, Alto, Hyundai, Colgate, Patanjali. So these kind of artistic work, if is available in your work which you are submitting for the registration, then you need to have a no objection certificate from the trademark authority under section 45, and then only you can file an application for the copyright registration. Another artistic work is in the form of design. Suppose you make a design and you want to get registration under the copyright, then as per section 15 of the copyright act, you will have to submit an affidavit stating it has not been registered under the Design Act 2000. Another point is it has not been applied to an article through an industrial process or reproduced more than 50 times. So And in another the third mode of the artistic work is, suppose you made a scenery, or you made a some artistic design or character. These are the three kinds, or these are the three work. Under the artistic work you can have a registration. So no objection certificate by the person whose picture is appearing on the work. Suppose there is an artistic work and you want to get an registration under the Copyright Act, you will have to take a no objection certificate from the person appearing in the work. Second, if the artistic work is used for the goods and services, you will have to take TMC, which is called the TMC, no objection certificate, from the Trademark Authority under Section 45 of the Copyright Act. And if the artistic work comprises any design, then you will have to give the affidavit of stating that it is not registered under the Design Act. What documents are needed for the sound recording and cinematograph film? You will have to give the no objection certificate or an agreement from various other person involved in the creation of the work. Suppose I sing a song and want to get a registration for the sound recording, then I will have to give the no objection certificate or an agreement from various other persons involved in the creation of the work. This is not needed if the applicant is the sole creator of the work. Suppose if you are the sole creator of the work, then no need to give any sort of affidavit or no objection certificate. You will have to just mention that I am the sole creator of the work. So in that case, you can apply the application along with the sound recording in the pen drive, or in the CD, or in the DVD. Same in the case of the cinema photograph film. If we talk about the computer software registration, then in that case, you will have to give the source code only. If the source code is comprised more than 20 pages, then you will have to give first 10 pages and the last 10 pages of the entire source code. So these are the document you needed at the time of filing the copyright application in different category. So excuse me, can I have a slides? Hello, I'm audible.
Yes, sir. So we have
Yes, sir, you
changed
are
to slide number
perfectly
2.
audible, sir. अभी पाओ ऑडियो गया.
Hemant sir, yeah, can you see the slides? It should be on steps from filing to registration.
Just wait, man. एक मिनट रुकना. ये slide. Just wait. It's processing, I think.
Is it visible now?
Yes, Damini, I think now it's visible. Hemant, sir.
Can I go for one from start one slides? Starting
Sure.
from the first. So next slide. So these are the subject matter of the copyright and the different artistic work we are getting the application for the copyright registration. One is literary work, artistic work, dramatic work, musical work, sound recording and cinematograph films. Next slide, ma'am. So this is the basically the process we are following to give the registration of the copyright. First, we receive the application in the copyright office. There are two modes you can file an application. One is offline mode, another is a online mode. Online mode is very simple. You just want to get a login ID. You have to create the login ID, file an application. Uh, After receiving the application, we do the formality check. In this, we examine the application whether that particular application is registrable or not. One thing. Another thing, the applicant has filed in the in respective category of the work. Then, if the application is absolutely okay, then the application goes for the advertisement. The advertisement period is for 30 days. This is called the waiting period. In this, we want, if somebody likes to have an objection or want to file a opposition to the application which we have advertised, they can file objection within 30 days. Suppose no objection is received within 30 days, then the application straightaway goes for the scrutinization. Scrutinization is done by the examiner of the copyright. If no objection is received by the examiner within 30 days, then the application straightaway goes to the approval by the deputy registrar. Suppose the deputy registrar finds no discrepancies, then the application straightaway goes for the registration. If we find any discrepancy at the examiner level, then the application straightaway goes to the discrepancy letter generated and sent to the applicant. And if the discrepancy is not complied within 21 days, then the application abandoned. If the reply is filed and the examiner found it suitable, then the application goes for the approval and for the registration. We give the second opportunity if the discrepancy is not complied with within 21 days, then the second discrepancy letter is generated, and that reply is again scrutinized by the examiner, and if no discrepancy is observed, then the application straightway goes for the registration. And if the reply is not proper, then the application straightway goes for the hearing. Hearing is done by the deputy registrar, and if it finds suitable at the time of hearing, then the application gets registered. Otherwise, it gets rejected. Another slide, ma'am. So we are also having some neighboring rights in India that is uh, defined under the Copyright Act. Scope is to protect the literary, dramatical, musical, artistic, cinematograph, film, and sound recording. Exclusive right to the what exclusive right we are giving in the copyright is to reproduce, to perform, to translate, to communicate to the public, to have an adaptation. And what neighboring right which are enshrined under chapter 8 of the act, it is given to the performer who is a singer, actor, dancer, musician. Right for those person who is performing under the work. Producer is very well defined by the Anooja ma'am. So there are some performers right which has already been discussed earlier. There is some producers right, and one thing which is left at the time, which is the broadcasters right. Broadcasters' rights stem from their creative and financial contribution in assembling and transmitting the programs rather than ownership of the content itself. they are having the right on the signals which they are transmitting. When we are seeing the IPL matches, so at the time of the live broadcasting to the that matches which we are seeing on the IPL, these are the right given to the broadcaster. These are the broadcasting rights. Their legal protection arises from the act of broadcasting only, as the ability to transmit the signals grants them the specific right over the signals only. These rights are based on the work and investment they put on the program together and broadcasting them. We are not giving the right on the content in itself. We are giving the rights the only to broadcast that signals. Next slides, ma'am. So, what recent development we are seeing in the copyright? India ranks 39th out of 133 countries in the Global Innovation Index released by the World Intellectual Property Organization. Significant process from 2015, where we were at 81st rank. If we talk about the registered copyright society, then India at right now we are having five different societies, copyright societies in different works. In India, ordinarily we have one society for one work. So this is the reason that today we are having five registered copyright society in different work, which has already been discussed by Anooja ma'am. Uh, if we talk about the copyright office thing, like we are having a digital environment over there. If you see that 96% application filed online, we have already done or introduced e-filing facilities. In hearing cases, we are doing video conferencing. We have already digitized all the available records since 1957. The Copyright Office or the Intellectual Property Right Office use the NIPEM program, that is a National Intellectual Property Awareness Mission, where we have targeted more than 2 million students, and we are also doing the same thing again. If we talk about the judiciary in this sector, the judicial measures and ruling in the copyright, several Indian high courts, including Delhi, Madras, Calcutta, have established specialized IP divisions, benches to handle IP matters for faster and more efficient resolution of IP disputes. Bombay High Court ruling in favor of equal royalty rights for the authors. Delhi High Court landmark judgment held in the copyright of screenplay does not vest with the producer of himself but with the author of the work as well. If you see, we are also having the IP Manthan platform to discuss and perspectives align Indian Intellectual Property Office with the stakeholders' expectations. And we have already launched the open house discussion every Friday from 4 to 6. If you are facing any difficulty while having filing an application, or any sort of difficulty of getting a copyright registration certificate, then you can join the open house session. The link is given under the website of the copyright and IP India as well. Next slide, ma'am. So these are the future of the IPR of the India. We are thinking to give more awareness to the public and protecting the intellectual property rights, unleashing innovation and creativity, as well as increased number of copyright applications. We are having a population of 100, more than 145 crores, and you will be surprised that we are getting only 5,000 application or 4,500 application in a month. So it doesn't mean that we are not creating the things. We are creating the things. We are having more than 100 of journals. We are writing. We are posting on the websites. We are posting the content to the YouTube, etc. But what thing is, we are not getting the copyright. We are not filing the application for the copyright registration. There may be the two things that I personally believe. That one, the copyright is automatically granted whether you are having a copyright registration or not, but it doesn't mean that we are not filing the application. We must have a copyright registration certificate, because this is the prima facie evidence which we can submit in front of the courts. So if we see the stronger legal protection, we must have some evidences, that prima facie evidences. So robust judicial support in place of stronger protection of the authors and creators, progressive judicial approach towards upholding the sanctity of copyright laws in India. We are trying to modernize IP offices, IP management system in India, which focus on modernized the infrastructure, recruiting new talent pools. We are trying to have young professionals. We are having internship programs. We are going to appoint more than 200 of examiners, 400 examiners for the trademark copyrights, streamlining the process for registering and managing intellectual property. If we talk about the international collaboration, we are having different meetings with the AI and the different booming sectors. We are having the digitization, building international alliance and harmonize the IP norms. Boost India image as a country that respects the value of intellectual property, because this is only the things that the global innovation index is. We are heading with many of the countries, and that only be done when we all unite together and we know the value of the IP, not only in the form of copyright. We must accelerate in the trademark, GIs, patent, semiconductor, and design as well. So this is the basic thing we I like to tell you. If you have any difficulty or filing regarding problems, you can write to me at any time. My email ID is hemantk.tamer@nic.in. You may visit to the copyright office website as well. So this is the thing which I want to tell you. Thank you. Thank you, ma'am. Not audible.
I'm am I audible now, sir?
Yes.
Okay. Thank you so much, sir, for your valuable time and for the insightful session on copyright law. So now, I think we have a few questions uh, in the chat box. So we will raise one by one. So Dr. Vinaya is asking, we applied for a copyright We applied for a copyright, replied with all the documents within time. No response from the office since 8 months. So, sir, could you please advise on how to proceed further?
I already told you that you may raise these queries on the open house session as well. There is a website. We are having the contact details, all the contact details on the website as well. Even then, if it is not sorted out, you can email me. I'm just writing my email. Just wait. You can give me a mail as well. These two email ID I have given you. You may write to me, and then I will definitely revert on this. Any other query relating to some documents or the concern?
Um, sir, in YouTube comments, there is one query from Ashish Singh. Right? He's asking if poetry is recited at any public place, can it be protected later on as copyright created by all?
So what Anuja ma'am has already pointed, she was saying absolutely right that uh, the copyright is the automatic right. So as soon as it comes to the knowledge of the public, the right created. Suppose I have an idea, it is not directly going to have a protection over it unless it is communicated to someone. So medium may be different, but you may have a registration on the literary, maybe in the form of the literary, artistic, musical, cinematography, sound recording, maybe in any mode. You can file an application afterward as well.
Okay, thank you so much, sir. So one more question from the YouTube comments. In India, many believe it's not important to register a copyright, especially in case of traditional art forms like folk music, which aren't even protected under GI. So how can we ensure these cultural expressions are preserved and protected from misuse or misappropriation?
Ma'am, actually, what we expect to have an application, there must be an originality and there must be some creator of the work. If there is a originality, if there is a creator, and that application is filed by the author himself, then we give the registration on the copyright. Otherwise, not. So basic requirement is there must be a original author and the creator of the work. We are considering the application in that case and giving the registration. Otherwise, not. So this is the test you will have to pass.
Okay, thank you, sir. I think it cleared your doubt. So one more question from the chat box. If I created content while working for an organization, who owns the copyright?
Ma'am, I didn't get you. Can you repeat
Uh,
it?
he's asking if I created content while working for an organization, who owns the copyright?
Ma'am, the same thing has already been, I think he didn't listen at that time. Anuja ma'am has already stated that there must be some contract. If there is a contract that whatever you are creating under my contract, then the ownership will lie to the person, the employer. If but the author will be the same. The whoever created the original work, the author will be the same, but the owner will be the person under the employment you have created the work. But if there is no contract, suppose I'm working with the government of India, and after this working hour I make some research and it is not related with my work, then I will be the owner of that work, because that whatever we I have researched, it's not under my employment, it's not under my the service condition. So in that case, uh, there must be we will have to see the moral rights as well under section 38. It says the author will have the moral rights. The first right gives to the author, and if the work is created under the course of employment, the employer will be the owner of that work. If it is not, then the author will be the real owner of the work.
So in line with Preeti is asking, in case of any book, who owns the copyright, author or publisher? By book, she
If you
means
have signed any
academic
agreement
content.
with the publisher, if you have signed any agreement with the publisher and you have given the NOC to the publisher, but what we are doing right now, even I did the same thing when I was writing or publishing some articles. So what publisher does, they give the NOC or a sort of thing that you will have to sign whatever the article we are going to publish. The publisher will have all the rights. So in that case, if you have signed that particular agreement, then definitely the publisher will have all the ownership right. If you didn't, then definitely the author will have the first right on the original created work, not the publisher.
Thank you, sir. Next question is, can a thesis or project or idea be copyrighted? If so, what are the documents needed? Is NOC necessary for this?
That I have already stated. If in the case of literary work, first you will have to file the Form 14. If the author and owner is different, then you will have to give the no objection certificate from author. If the work is the published work, then you will have to take the no objection certificate of the publisher. If the application is filed by the attorney, then the power of attorney needed. If the application is filed by the company, then the board of resolution or letter authority in favor of the signatory is needed. So these are the document you will have to file at the time of filing the literary application. So in case of the novel, you will have to give the if the author and owner is different, then you will have to give the no objection certificate of the author. If author and owner is the same, then no need to give any sort of evidences. If that is a published work and the publisher is different, then you will have to give the no objection certificate from the publisher itself.
Okay, thank you, sir. I think it is, you have given a clarity on this. Now, few more questions from the YouTube. Jishnu is asking, how much cost is involved in copyright filing to approval?
Uh, in the case of the sound recording, you will have to give the 2000 rupees, that is the government fees. And if that is a cinematograph film, then you will have to give the 5000 rupees DD or the online
Okay,
transaction you can do.
yes,
And
thank
in
you, sir.
case of the literary work, you will have to give the 500 rupees. And for the artistic work, there are three ways you can file the artistic work. One, uh, the artistic work which is used for the goods and services, you will have to give the 2000 rupees. If the artistic work is in the form of design or it is a scenery, then you will have to give the 500 rupees. If the artistic work is in the design, then you will have to give an affidavit as well under section 15 that that particular artistic work is not registered under the design act and it is not reproduced more than 50 times. That affidavit you will have to give in the case of artistic work in the form of design. So this is the fees we are getting from the applicant.
Thank you so much, sir. And another question from IISU Incubation Center. What's the difference between licensing and assigning copyright?
And if we talk about the licensing, right now we are not having any application of the licensing, and no license is issued yet by the Copyright Office. However, as far as the assignment is concerned, we are having a Form 15 which you can file offline. In this in form for 15, you can have an amendment or you can assign your copyright to the different entity. For that, you will have to give the agreement deed or the no litigation pending in the court. These two documents you will have to file along with the Form 15 request, and then it is examined and given the Form 15 registration certificate.
Okay, thank you, sir. Another question. He's asking, how does the concept of fair use limit the exclusive rights granted by copyright law? And what are the key factors courts consider when determining whether a use is fair?
Uh, Again, this is not basically we are dealing with in the Copyright Office one thing, because the
Mm,
Copyright Office is basically given the registration to the copyright owner. Another, we are receiving the application of the Copyright Society and giving sent back to the central government for the consideration. These two works we are doing right now. As far as the fair use is concerned, this is purely uh, again the debatable thing, like whether it is the matter you are using, that is you are used not for the commercial gain, So there is a principle of unjust enrichment, that you are no one can enrich himself on the work of another. So if the you are using anything, any literary, artistic, dramatic work for the research purpose, then it is under the fair use, otherwise not, which is correctly enshrined under section 52. You may have see section 52, where it is clearly mentioned and drafted very well, what is fair use and what is not fair use. Same in the case of section 251ZA as well. When you are using some songs in the marriage ceremonies or not, which is a very debatable thing right now. It is also pending in the High Court. So this is the thing.
Okay, sir. So, few more questions. Like, Bhupati is asking, if a student writes an original poem using software-assisted tools, who owns the copyright?
So again, that is the AI generated
Yes.
thing you are talking about, and right now we are not giving or we are not having some laws to protect the AI generated work. However, if you have already generated the poem through computer software, suppose I have this way. So, what suppose I am writing some poem in MS Word and then in PDF format, then we are giving, then the right will belong to definitely from the author or creator. But if it is generated through some AI generated tool, then the same thing, we are not giving or we are not entertaining anything. We are not giving registration on AIJ. However, that is we are having SCCR on it, a Standing Committee on Copyright and Related Rights. Whole world is on the same thing. However, US Copyright Office has made a research on this, and you can have a report on this. Some sort of things like some sound recording or something like that, they are giving some content registration, but again that is not a totally AI generated thing they are protecting. So you can have a right, or you can have a read of the US research on this.
Okay, thank you, sir. And few questions from the YouTube also. Are there any upcoming reforms or government initiatives aimed at making copyright registration and enforcement more accessible and efficient for individual creators and startups?
uh, as far as whatever we are receiving for the copyright registration, we are putting on the website. If you want to see what copyright we have given or what registration we have given, what sort of work we have already registered, you can, it is easily accessible to the copyright website. Even that is fully but we can say given on the website. So I don't think so anything we are hiding right now. Even we have opened the platform where you can have the different queries. That is initiative taken by the our commerce minister, and the same thing is taken up by our controller general and the registrar of copyright, and many more things we are having a lineup and we are doing for doing all the transformation of the copyright as well. So this is the thing.
Yes, sir. Thank you so much, sir. So one more last question. So Pratusha is asking, how can you identify fake publication from the market other than the AI generated?
Can you repeat it again?
Like, how can we identify fake publication in the markets?
Again, this is the question. I don't think so. Sorry, sorry for this question. I will get back to you on this because I didn't have so much knowledge on this.
Yes, sir. So thank you so much, sir, for your valuable and insightful session. Now, I formally invite Ms. Indu Kovind, who is the Innovation Manager from Kerala under MIC. So over to you, Induji, for the concluding session.
Yeah, thank you, Shruti. Hope I'm audible.
Yes.
So good afternoon, everyone. On behalf of Ministry of Education's Innovation Cell and AICT, I would like to thank each and every one of you for joining today's enriching session on copyrights as a part of IP, the day 3 of IP UTSAV. A special note of thanks to our distinguished speakers, Dr. Hemant Khosla, Deputy Registrar of Copyrights, Government of India, and Ms. Anooja Padhee from K&S Partner for so generously sharing your time, expertise, and experience with all of us. Ms. Anooja beautifully, she set the stage by walking us through the fundamentals of copyrights, laying a strong foundation of understanding their importance in creative and the academic ecosystem. Building on that, Dr. Hemant Khosla, in his dual capacity as a deputy registrar and a senior examiner of copyrights, offered us rare and valuable insights. Basically, more specifically saying like valuable insights into the whole of the application procedure of the copyrights from the IP office perspective. His detailed insights truly demystified the practical aspects of filing for a copyright, making the session not only informative but also deeply impactful. Thank you so much, sir, for your time and such a impactful presentation. To all our participants, thank you so much for your thoughtful engagement, meaningful questions, and enthusiasm throughout the session. Your active involvement make the celebration more vibrant. Last but not the least, I would like to thank Shruti and Damini and also the whole of the IT support team for their seamless coordination and technical support in setting up and managing today's online session. So as the IP also continues, we hope that today's session has left you more inspired and informative to appreciate, protect, and promote the creative work. So we hope for your continued support. And thank you so much once again for all of you for joining with us today. Thank you.
Thank you, everyone, for your valuable time. Thank you so much.